You may be seated. Thank you. This is an oral argument on the petition of Eagletech Communications Incorporated of the initial decision of an administrative law judge. In addition to the commissioners present today, Chairman Cox will participate in this matter by reviewing the transcript of this oral argument. A total of 30 minutes has been allowed for the argument, divided equally between respondent and the Division of Enforcement. Respondent will argue first and may reserve part of his time for rebuttal. Mr. Young, you may proceed. Do you wish to reserve any time for rebuttal? Okay, thank you.
Good morning, Commissioners. My name is Rodney Young. I am the founder, president, and CEO of Eagletech Communications. The SEC Enforcement Division has requested that all classes of Eagletech securities be revoked for delinquency in filing its financial reports. Administrative Law Judge William Kelly has so ruled. The division argued that without transparency, a potential investor couldn't determine even such basic information about the company as the number of shares issued and outstanding. Eagletech's affirmative defenses allege that the SEC itself possesses information that is equally or even more important to transparency, that is, delivery failures. The current SEC policy refuses disclosure of such data to the issuer. Without it, even compliant financial reporting by any company is a distortion of its condition to investors. Eagletech further alleges that the SEC was a contributor to its delinquency when in January of 2002 and again in June of 2002 and yet again in July of 2002, complaints of its victimization by death spiral financing and naked short selling schemes were ignored. Even the intervention of U.S. Congressman Peter Deutsch on behalf of Eagletech got no response. I believe that the SEC, the DTCC, the Federal Reserve, and members of Congress all share responsibility for failing to respond to tens of thousands of complaints of wrongful conduct from victimized companies and their shareholders. Those failures have unwittingly facilitated an unlawful market manipulation on a scale unimagined by any previous experience. Judge Kelly ruled against the company on the only question put before him. He also acknowledged in his initial decision the other dynamics in this proceeding. He acknowledged Eagletech's submission of market manipulation evidence and then went on to state, Eagletech contends that by grandfathering all pre-regulation SHO delivery failures, naked short sellers will never have to purchase shares to cover their naked short positions. This policy argument should be addressed to the Commission. He went on to state, decisions not to enforce are presumptively unreviewable. The presumption may be rebutted where the substantive statute has provided guidelines for the agency to follow in exercising its enforcement powers. Eagletech also alleged in its affirmative defenses that grandfathering pre-regulation SHO delivery failures is a constitutional tort and that the SEC has violated the Fifth Amendment property rights of shareholders, an illegal inverse taking of their property. The substantive statute here is Rule 17A of the 1934 Act. And I quote, Congress finds that the prompt and accurate clearance and settlement of securities transactions are necessary for the protection of investors. Nowhere is there a rule of law which gives the SEC discretion to suspend the settlement process. Clearing is the collecting of the buyer's money. Settlement is the delivery of the goods. Suspension of settlement or grandfathering equals the taking of a shareholder's property. Every shareholder of any company in America who can't get delivery of his shares has a cause of action for violation of his Fifth Amendment constitutional property rights. Just 2 weeks ago, former SEC Chairman Arthur Levitt, in response to the Jack Abramoff scandal, was quoted in the Myrtle Beach Sun. The concerns of ordinary investors often were subsumed to the interest of industry lobbyists. Every day, the SEC would receive letters from lawmakers opposing some proposed regulatory change, letters that mimicked one industry trade group or another. When all else failed, lobbyists would influence members of House and Senate committees to threaten the SEC with budget cuts to get what they wanted. Regrettably, I occasionally found myself succumbing to this immense pressure in order to save the Commission. Many of the reforms that were thwarted in this way could have saved investors some of the pain from the scandals of the past 5 years. My own experience is consistent with Chairman Levitt's. Interference from outside forces first surfaced in June of 2002 when the first ever major media story on this subject appeared in Forbes magazine, an article featuring Eagletech's manipulation. A few days after its appearance, a Washington, D.C.